Good morning. Happy Tuesday. I apologize for not being very active. My work life is incredibly busy right now. Last week, I left work one day at 4 o'clock. The rest of the time, I was getting home at like 8:30, 9 o'clock at night. So, I mean, I'm thankful for all the work. You know, my pocketbook is happy with all the work, but it doesn't leave a whole lot of time for sitting around reading briefs and making YouTube videos and live streams and things like that. And I'll be perfectly honest with you, I do this for fun. You know, none of this is monetized. None of this is how I make my living. So if I have other things that I want to do that I find to be more fun, like make a live stream on the fishy side of my fishy hobby, then I'll do that instead. But today, I've had questions about, I've had people want me to read the decastro versus lvmpd filings, and I may at some point. I'm not really sure how much interest they have to me, because it's going to go a couple. So procedurally speaking, Chili's, I believe, was his first amended complaint. All of the issues were dismissed with prejudice, except for the issues surrounding excessive force, state law claims surrounding excessive force, and the Fourth Amendment claims about excessive force. Everything else was dismissed with prejudice, meaning it's dead. At the trial level, it's dead. In the district court level, it's dead. The way it's supposed to happen is that he files a second amended complaint, which he did, realleging the portions of his complaint that were dismissed without prejudice. He chose to reallege everything, which whatever. And then the trial court will, eventually come to some sort of ruling or judgment on the remaining issues, whether dismissed with prejudice or whether it goes to trial and there's a judgment on those issues. And then Chile is supposed to appeal the issues that were dismissed with prejudice. And then if the Court of Appeals disagrees with the district court, those issues get sent back down to the district court. Because you can only appeal, hashtag generally speaking, not all, blah, blah, blah. You can only appeal final decisions that dispose of the case entirely, right? Hashtag technically, blah, 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 right? Your mileage may vary. Talk to a local attorney. So that's what's procedurally supposed to happen. However, the court has a lot of discretion. So what the court could do is sua sponte decide to revisit its decision about the dismissal with prejudice, taking into account the outcome of Chile's court trial, taking into account Wilson versus Superior Court, which the court may or may not have taken into account in its first run through, and the court may decide to set aside its dismissals with prejudice and then proceed, basically as though it had just dismissed them without prejudice. It could do that. And, tactically, strategically, I don't know if that is a better outcome for Chile or a worse outcome for Chile. On the one hand, if the court looks at it again, this is going to give Chile two bites at the apple. Bite number one, if the court doesn't agree with him, well, that sucks. He still has bite number two, the appeal. So that's the positive side of that. The negative side of that is the lower court has already looked at it and has already found that there was probable cause. So the court is very unlikely for it to come back and say, well, actually, there was no arguable probable cause because, and the court's only looking at probable cause. It doesn't matter that Chile was found not guilty. It doesn't matter at all. What matters is did the cop have arguable probable cause to make the arrest? That's what matters. That's what the court's going to look at. Did the cop have arguable probable cause? Not probable cause, but arguable probable cause. It's an even lower standard than probable cause. It's whether or not a reasonable cop would have thought that he had probable cause. Not did he have probable cause, but would a reasonable cop think he had probable cause? You see how almost negligible the standard is? It's a very low standard. It's really designed to just catch cases where cops absolutely know they shouldn't be doing anything, but do it anyway. That's the instance it's designed to capture. You know, this isn't what I want it to be. This is what it is. Like, go fucking Google it. It's arguable probable cause. Like, I'm sure whether I like it or not is immaterial. This is the standard, just so you know. So on the downside, the lower court has already made a determination on it and is unlikely to say, well, actually, there was an arguable probable cause, despite the fact that I came up with the conclusion that there was probable cause, despite the fact that the district attorney thought there was probable cause, despite the fact that the first court found him guilty. Despite all that, there's actually no arguable probable cause. Very unlikely that the lower court's going to do that. And then if you go up to the appeal, appellate courts tend to be pretty deferential to the lower court's decision, tend to be #your mileage may vary. Most appeals are rejected, or they give a slip opinion saying, no. So your odds of success are lower. Well, maybe lower. On the other hand, if the lower court says no, I've already dismissed this with prejudice, wait till the end of this and you could appeal. If the court does that, well, then Chili may have more. He only has one bite at the apple, but he may have a better chance of success, because when he gets to the Court of Appeals might say, well, the lower court didn't consider the Wilson decision, and so I'm going to reverse and remand back to the lower court to have the lower court consider the Wilson decision. Might be a better outcome, but you're still, best case scenario, it goes back to the lower court, and the lower court will probably still find arguable probable cause. If the lower court already found probable cause, it is most likely going to find that there is, at a minimum, arguable probable cause. It might find that there was probable cause, but it's almost certainly going to find, you know what I'm saying? I'm not saying I know people want to try to lock me into bright line rules and hard and fast statements of what is going to happen, but this is a most likely scenario. Most likely the lower court is going to say there was arguable probable cause. It's very low standard. I've explained why. If the lower court already found probable cause, it's going to most likely find there was arguable probable cause. And it can take into consideration that the Wilson ruling was, I think the Wilson ruling came out about a month, maybe a little bit less than a month before Chili's arrest, maybe a little more, but right about in that month mark. I don't remember exactly. But it was a brand new case when Chili was brand new ruling by the Nevada Court of Appeals. And just so everybody is aware, the district court case doesn't mean shit. Like, the district court appeal and the ruling of the district court in that appeal doesn't mean shit. Like, it literally doesn't mean shit. I'm not saying this because I don't like Chili. I like Chili. I wouldn't hire him to represent me or trust his legal research, but I don't have anything against him. I know people want to think that I have something against him. He's a dumbass and he writes stupid pleadings, but I don't actually have anything against him. And again, I also think that Terry versus Ohio was a shit decision. Your mileage may vary on all of this. But the district court's opinion doesn't mean anything. It's not precedential. It's not binding on anybody or anything. It doesn't matter. And the baseline, the reason why there's the younger abstention and all these other abstention doctrines that were being pled in Chili's case was because the district court is not supposed to get involved in the case until Chili is either, some of these things, if he's convicted, he might lose causes of actions. But generally speaking, most 1983 lawsuits are filed after they're found not guilty, after they've been exonerated somehow. That's where most 1983 lawsuits, successful ones, come into play, because the state court proceeding's done, And hey, you know, I've been found not guilty. I'm going to sue. If you haven't been found, if you have not been found not guilty, if you've been found guilty, I should say, you lose a lot of your causes of action for a 1983 lawsuit. You can't say wrongful arrest. You know, you can't say I was arrested without probable cause, because you've been convicted, bro. Like there's just no way around it. You've been found guilty beyond a reasonable doubt. So you lose a lot of causes of action if you've been found guilty. So the operating assumption is that you've been found not guilty when you file your 1983 lawsuit. So Chili being found not guilty, it doesn't really change anything. Like, I know for Chili fans, it was a huge thing. I mean, for Chili haters, it was a terrible thing. But as far as the 1983 lawsuit, decastro versus lvmpd, it was not a big thing. It was not a big thing. Chili could have still argued Wilson. Well, no, because if you'd been found guilty again, he would have lost a lot of his causes of action. But if like, let's just say that the district attorney had decided just to, was it the city or was it district attorney? I think it was district attorney. If the district attorney decided to drop the charges, it wouldn't have changed anything, even if he didn't have that decision. You know what I'm saying? Like, the decision didn't change anything, really, unless he was guilty, in which case it really effed his, it would really have effed a lot of his causes of action. Anyway, so what's going to happen next? I think the lower court will, I think in the interest of judicial economy, the lower court will likely make a ruling on whether or not the cop had probable cause again, despite it having been dismissed with prejudice. I think because both sides are arguing it, because both sides seem ready to litigate it, my best guess would be that despite it being procedurally not right, the court will look at it again and will render a decision again based on the arguments made about Wilson. Again, remember that all the cop had to have was arguable probable cause. Would a reasonable cop in that cop's position think that he had probable cause to make an arrest? Now, whether or not he did have probable cause, but would a reasonable cop in that position think he had probable cause? And again, that's just, even if the lower court had not found that there was probable cause, it would still be a tough burden for Chili to get over. So, my betting would still be not for Chili to recover if this goes all the way to trial. My bet is it's still going to get dismissed or mostly dismissed before trial. And the only triable issue that I can see is going to be the excessive force claim. And I don't see a jury finding that there was, by a preponderance of evidence, that there was excessive force. And he hasn't set up anything, as far as I can see, to recover. He hasn't set up any damages, so he's probably just going to get nominal damages. It's still just a pretty shit deal. Now, one other thing, attorney, not John, but the attorney, MEE, is still representing Chili in the case. People are like, well, why? If he was such a bad attorney at the criminal case, why is he still in it? Well, there's probably several reasons. First of all, he didn't do that bad at trial. He didn't find the Wilson case, whatever. I mean, that doesn't mean necessarily ineffective assistance of counsel. I don't really think that he did that bad. Like, he wasn't a rock star, but it was mediocre. It was what I would have expected from a public defender. I mean, the guy makes his bones on getting settlements. The guy advertises basically that he will get you a plea deal, that you won't do jail time. That's how he's a settlement guy. So he still makes excellent sense for Chili in this case, because he still might get a settlement for Chili out of this case. And a settlement is where Chili would actually get any money. Chili should be focusing on getting a settlement. Because, I know he wants to make a point, but he should focus on getting a settlement. Money talks pretty loud. I'd get a settlement. I'm an attorney. This is what I do for a living. So I'm maybe a little bit biased, but get a settlement. And me seems like the right guy to get a settlement, because me is a settlement guy. Another thing that people might not be considering is that I know in my contracts for contingency-based fee agreements, if you fire me without cause, or if I fire you with cause, I will insert a lien into your case. There will be an attorney lien. I'll file an attorney lien in your case. And so if and when it does settle, I get notified and I submit my lien to the attorney that you have at the time, and I'll get paid. I mean, I might not get as paid as much as I want, but I'll get paid. You know what I'm saying? Like, and the attorney, any attorney that you get subsequent to me will know I've been in the case and will know I'll have an attorney lien. And so, anyway, long story short, there's probably an attorney lien somewhere in the contract if Chili fires me without cause, and the cause would probably be in the case, not in any case, but in the case. So when decastro versus lvmpd has me screwed up, no, okay, me gets to stay in, or else he gets to assert a lien. And if there's not enough money coming out to satisfy my lien, I could, in theory, sue the client. I wouldn't. Me might. I'm not me, I'm different than me. He might sue the shit out of the client. I don't know. So anyway, thanks for watching. And I've got family coming over this weekend for Labor Day, so I probably won't be on for I don't know when I'm going to be on. I got a lot coming on. November is going to be just slammed. September is already looking pretty packed. I mean, I don't know when I'm going to be on again. So, but I'll try to make little videos or whatever, because I know some people actually like to hear from me. Anyway, thanks for watching. Have a great day.